Mr. Chairman. Much of what the majority is proposing to do today in this bill appears to be designed to weaken the scientific independence and integrity of the Science Advisory Board. One of the ways that this is accomplished is to make it more difficult for academics and government scientists to serve by prohibiting scientists from serving who have worked on the issue being reviewed. At the same time, the bill makes it harder for independent researchers to serve on the board. The bill does, however, encourage greater participation by industry groups. Now, if you agree that credible peer review is important, I'm not certain how that is accomplished by providing for service by industry groups, but prohibiting service effectively by scientists who have specialized experience with a given issue. I think this is a really terrible trend, and I think it's clearly one that's designed to subvert the scientific review process. Now, I'm not an unreasonable person. I think industry scientists and engineers can bring relevant and unique perspectives to the table, and that they should be included in this process. My amendment would allow those people to serve on the board. However, my amendment limits their participation to 10% of the board because we don't want the industry to dominate or co-opt the review process. There's a difference between participation and domination, and my amendment ensures that the board doesn't become dominated by corporate interest. You know, I think the American public would actually be appalled if the National Toxicology Program's Board of Scientific Counselors was dominated by scientists from the tobacco industry. It would be considered an outrage. It would no less be an outrage if we allow the EPA's Science Advisory Board to become dominated by the petrochemical industries or other interested industry groups. These industries are not looking to unearth the best science. They're looking to protect their bottom line. That's what they should do. They're corporations. But because of that, their participation on this board should also be limited. What happened in the last century with the organized efforts of the tobacco industry to subvert the scientific process with regard to the negative health effects of smoking was a dark stain on the country. Many people died because of those efforts. How many people suffered through horrible diseases because of that? I really am concerned that we're going to allow that process to repeat itself here if we don't try and protect the integrity of the EPA's scientific review process and indeed to protect the science. I think my amendment is a reasonable attempt to accommodate the industry while also safeguarding the integrity of the Scientific Advisory Board, and I urge adoption of the amendment. And with that, I yield back. I think if the gentleman would acknowledge that what my amendment does is that I acknowledge that, and even in my statement, that diversity is important, that it's important to get the expertise of the industry, but not to have it dominated on these boards. And what my amendment provides for is that not more than 10% of the board can be comprised of for-profit entities. And in that way, the SAB that you described with 50% would actually have at least 5 industry representatives on the board. Thank you.
Thank you, Mr. Chairman. I think it is very important for this committee to support Ms. Edwards' common sense amendment. The amendment ensures that the SAB cannot have employees of for-profit entities comprise more than 10% of its members. I am all for balance, and I believe there is a place for employees of for-profit entities to sit on the SAB. However, I am also for a balanced advisory board, and I think we all should be. By capping the number of employees for nonprofit entities at 10%, we ensure that the very important voice of industry is heard without overwhelming the other stakeholders of our society. It is truly concerning to me that without this amendment, we could find ourselves in a situation where a single industry dominates an SAB panel. If this occurs, it would be a travesty of the very nature my Republican colleagues say they are trying to prevent with this bill. If my colleagues across the aisle are serious about balance, then they will support this amendment. And to ensure balance and fairness of these panels, I urge my colleagues to support this amendment. I yield back.
Because in the underlying bill, the limits that are then placed on scientists who have had some other interest and been funded would restrict their participation. I have another amendment to that effect, but would restrict their participation. And so at the end, you're left without the kind of expertise that you need that we all agree on. And I think that what my amendment is doing is trying to strike that balance. It says, yes, we have industry experts. We just don't want the SABs dominated by those industry experts or the scientists who have specialized experience limited from their participation too. And it's the combination of those things.
Mr. Chairman, I move to strike the last word. Let's go over this here. We're talking about the Environmental Protection Agency. The charge of the agency is to protect the environment. Generally speaking, threats to the environment are produced in our country by private profit-making entities. I think that goes without saying. I'm sorry, that's the fact of the matter here. The Scientific Advisory Board that we're talking about is supposed to provide independent scientific advice to the EPA so that the EPA can make its decisions properly. This agency, like every other government agency, is threatened with the possibility of capture by the people whom it's supposed to be regulating. What this bill does, in essence, is facilitate that. This bill allows and encourages private industry to take over the Science Advisory Board at the EPA and therefore exercise control. The regulated will be exercising control over the regulator. That's what this bill does. Now, I speak in support of Ms. Edwards' amendment because we need to prevent that from happening. Perhaps certain members of the majority on this committee believe that 10% is not the right amount. I understand that. Maybe the right amount is 15%. Maybe the right amount is 20%. Perhaps Congressman Edwards would accept a secondary amendment to that effect. I can't speak for her. But the fact is that if we don't put in any limitation here, what that means is that we are encouraging and inviting industry to take over these science advisory boards and therefore take over the EPA. That is a real and present threat. I'm not questioning the intent of the people who drafted this bill. I am questioning the obvious and necessary impact of this. We cannot let the EPA be populated by corporate tools and corporate shills. And that's exactly what this bill, without the amendment offered by Ms. Edwards, actually would do. That is the effect of this. Therefore, I support the Edwards amendment as an effort to ameliorate what will inevitably happen, which is this bill, if passed, will mean that we'll have all the diversity on these scientific advisory boards so that we'll have opinions ranging all the way from Exxon to Chevron and nowhere else. I yield the remainder of my time.
We have the amendment at the desk.
And the clerk will report the amendment.
Amendment to H.R. 1422, offered by Ms. Edwards of Maryland, page 3, line 8.
Without objection, the amendment will be considered as read, and the gentlewoman is recognized.
Thank you, Mr. Chairman. In the amendment that I offered previously, we rejected the idea of some kind of limitation on for-profit entities serving on the Scientific Advisory Board. What my amendment, this amendment does is it actually strikes subparagraph E under Section 2A, and that paragraph reads, board members may not participate in advisory activities that directly or indirectly involve review and evaluation of their own work. And so on the one hand, we've rejected the idea of for-profit entities being limited, but we've said that people who actually have an expertise, even when it's their own work, aren't able to participate on the advisory committees. Quite an irony. I'm really concerned that this underlying provision will dramatically reduce the number of qualified scientists who can serve on a board. In many cases, these are people with a very specialized kind of expertise. In many fields of study, there are only a small number of qualified experts to draw upon. These experts routinely publish research with colleagues and peer review other colleagues' work. And because of these connections between researchers, this provision has the potential to significantly affect the ability of the EPA to draw on the specialized expertise of the scientific community. I would note that this provision would probably leave relatively unaffected many scientists drawn from industry, as much of their work is private and isn't publicly published due to patent concerns. nor is it peer-reviewed. However, scientists publishing in public journals would be greatly affected, the academic community, the independent scientific community, and maybe that's the intent, but I would certainly hope not. Just to give an example of how absurd this provision is, if something similar had been applied to the Manhattan Project, the country's most eminent nuclear physicist would have been barred from advising the government. Obviously, that would have been disastrous, and it would be no less disastrous for the Scientific Advisory Board. This is a bad provision and should be stricken from the bill. I urge adoption of the amendment, and I yield the balance of my time.
Now let's take a different approach to this. My amendment today is simple. It's meant to ensure that 10% of the Environmental Protection Agency's Science Advisory Board will include individuals from public interest non-governmental organizations. Specifically, it requires that those individuals come from non-governmental agencies that represent public health, minority populations, women issues, children's issues, food safety, and other public interest non-governmental organizations. It's meant to ensure a diversity of opinions. I think ensuring that these community-based organizations with public interest missions have representation on the board is equally important to ensuring that 10% of the board be comprised of individuals from state, local, and tribal governments. The benefits that individuals who work in public interest organizations can bring to a group like the Science Advisory Board are profound. The sole purpose of these groups is to protect public citizens. To ensure that they have a seat on the board is a grave to not ensure that they have a seat on the board is a grave injustice to the needs of our population. As the former Chief Medical Officer for Sacramento County, I fully appreciate how the advice and input of non-governmental organizations can offer important opinions and on issues of public health. This amendment ensures that these vital voices are heard in the advice given to the EPA. This is not an expansive amendment. I'm only seeking to require that these type of individuals constitute a minimum of 10% of the board. I think that is reasonable given the diversity of public interest non-governmental agencies and that the disparate issues they're involved in. Moreover, from my personal experience, I know there are many technically proficient individuals in these public interest groups who are qualified to serve on the Science Advisory Board. I think this is a common sense amendment, and I hope everyone can support it. Thank you, Mr. Chairman. I yield back. From these non-governmental public agencies, they have to be experts on the panel. There are many experts that are going to come from these agencies, and there'll be just as many experts from non-governmental organizations as there are from the corporate sector and so forth. And each individual is going to be looked at on the merits of what they're doing. Again, it's obvious that they're going to be experts on the subject matter.
I want to state my support for Mr. Barrett's amendment. This amendment really makes a lot of sense. I think that if you really want to protect the integrity of the EPA's Science Advisory Board, then having individuals from public interest NGOs on the board would go a long way to ensuring that happens. The type of people who work at public interest NGOs truly have the best interests of the country at heart. These are people who spend their lives working to protect the American people, from NGOs that work on public health issues to those who work with minority populations or on women and children's issues. These NGOs touch on every aspect of the American experience. This good common sense amendment ensures that individuals who selfishly serve on these organizations can present their advice and opinions on the important issues that EPA, the SAB, addresses. When I think of the great work that NGOs that I have dealt with to help further the goals of STEM education in this country, it reminds me of the expertise that those types of groups bring with them, and I hope the majority can see the wisdom of this amendment. This bill seeks to change the balance of the types of individuals who serve on the SAB, and surely everyone can see the importance of including individuals from the public interest NGOs. I encourage all of my colleagues on this committee to support this amendment, ensuring that public interest NGOs have a position on the SAB. I yield back.
Mr. Chairman, this amendment prohibits registered lobbyists from service on the Science Advisory Board. If there are any members who want to extol the virtues of lobbyists and oppose this amendment, I'd love to hear it. I'll yield to him or her.
Thank you very much, Mr. Chairman. I support Mr. Grayson's amendment and thank him for bringing it forward. As I discussed when we were considering Amendment Number 2, which was broader in its intent, this is an important part of making sure that we have scientific integrity on the scientific advisory boards. And even though this prohibits registered lobbyists, I still have some concerns about others, for example, paid attorneys who are representing groups. So I look forward to continuing to work with the Chair and others going forward. That being said, I do support this amendment, and again, I thank Mr. Grayson and yield back.
My amendment strengthens the disclosure requirements of the underlying bill and improves the transparency for nominees to the EPA's Science Advisory Board. My background, Mr. Chairman, is as a former prosecutor, and I found in the courtroom, just as in this Science Advisory Board or any decision the government makes, it is always best for jurors or the public to have all of the information possible. And I believe that this amendment does allow more transparency and accountability. We owe it to the public to make it known what work the nominees have done and who paid for the work that was done. While I do have concerns about the underlying bill, I think this amendment makes an important clarification to the disclosure requirements and will keep and help ensure the Science Advisory Board is indeed fairly balanced and composed of the very best scientists this country has to offer. Mr. Chairman, I also appreciate the work that you and your staff put in last evening to work with my staff late into the evening to have this amendment put forward and accepted. And I do appreciate your efforts so far to try and make this a bipartisan effort. And with that, I encourage all members to support my amendment. And I yield back.
Thank you very much, Mr. Chairman. This amendment today is very straightforward. It's a simple good government principle that seeks to increase transparency and expand openness in government. EPA's science is tied to its mission to protect public health, and we're fortunate that some of the best scientific minds in our country that our country has to offer volunteer their expertise and time to serve on EPA's scientific advisory boards and panels. I understand the need for greater transparency in this process, and transparency increases public confidence and public understanding of how our government works to protect our health and our environment. Therefore, I am offering the following amendment to H.R. 1422, a bill that makes changes to the EPA Science Advisory Board process. The Board has a process that addresses recusals of Board members when situations arise that make a recusal necessary. EPA follows the practice of the National Academy of Sciences, the National Institutes of Health, and other Federal agencies when it comes to recusal. This amendment simply requires that when a member recuses himself or herself from the Science Advisory Board, committee, or panel, that information should be made available to the public. This amendment is in line with the spirit of the bill, calling for more transparency in the review process, and I encourage its inclusion in the bill. Thank you very much, Mr. Chairman. Again, Mr. Chairman, and thank you for working with myself and other members of this committee on this bill. During the legislative hearing that the Environment Subcommittee held on this bill, one witness, Dr. Francesca Grifo from the Union of Concerned Scientists, discussed with us recommendations that could improve the Science Advisory Board process. And she has a lot of expertise, having served on task forces and groups that looked at how this process could be better. As with my previous amendment, Dr. Grifo encouraged us to search for transparency and balance on these advisory boards, and this amendment seeks to do just that. Under current law, the EPA is allowed to waive conflict of interest requirements for nominees to science advisory boards, committees, and panels. This amendment will require the EPA to disclose those decisions to the general public unless prohibited by other provisions of law. The disclosure requirements in this amendment will bolster public confidence in EPA's decision-making process and free academics from unfair accusations about the integrity of their perspective. And I thank the Chairman for this opportunity to speak and again for working with us on these amendments, and I urge adoption of the amendment. Thank you very much, Mr. Chairman, and with that I yield back.
Chairman, this is really a very straightforward amendment. The underlying bill requires that we add new requirements to the EPA's Science Advisory Board process. These new requirements will undoubtedly cost money. There could be some debate about how much more it will cost, but it's clear that the increased costs will be significant. In fact, during the legislative hearing, we heard from experts noting that there would be increased cost, responsibilities, and process with this language. Just the subtle changes in Section 2B will dramatically increase the workload of the Science Advisory Board. The Board will now have to review and comment on all risk and hazard assessments conducted by the EPA. I suspect that will multiply the amount of work the Board has to conduct. Now, just to be clear, I don't support any of these new requirements. They appear to be aimed at slowing down or corrupting EPA's risk and hazard assessment process. Nonetheless, I think if you're going to increase the workload of an agency, it's incumbent on you to give the agency the resources it needs to accomplish the increased work that's required. And this is exactly what my amendment does. It simply says that the EPA administrators authorize such sums as may be necessary to carry out the requirements of this Act. I think it's a pretty reasonable amendment, and I hope everyone can support it. If you sincerely believe that the bill will make the Science Advisory Board function better, then I think you ought to be willing to pony up the cash to pay for it. And it's really that simple. I would urge adoption of the amendment, and I yield back. Ms. Johnson, I appreciate that. We didn't hear any testimony, for the record. We heard no testimony about the estimated cost. In fact, we didn't even hear from the EPA about the legislation. I wonder if the gentleman even knows how many risk or hazard assessments the EPA does in a year, and what's the provision cost for the EPA to comply with the ones that are currently done. And so I think that all of us, especially in this environment with deep fiscal constraints and concerns, should be concerned about adding requirements without having any idea at all about what those costs would be, and sort of saying, well, just trust me. The fact is that there's additional work, and whether it's nominal or not, there is some cost attached to that. And if we want the EPA to perform this additional work, I would think that all of us on this committee would say that it's our duty to make sure that the sums are available for them to spend on the additional work that we require. And I don't understand the reluctance to agree to a provision that simply says we're going to pay for the work that's required. And with that, I would yield back my time to Ms. Johnson.
Support of Ms. Edwards' amendment. And it's correct that we did not hear about the additional costs involved in this, but I want to point out that this bill includes a provision that the Board's report shall include written responses to significant comments offered by members of the public to the Board. Now, there is already a public comment period, and they're in these Science Advisory Board hearings, and there is already written comment that is submitted. However, this bill introduces a new requirement that the Board has to include written responses to significant comments. In addition to the fact that we don't know what significant means, this appears to be yet another way that this process could be delayed and slowed down so that the Science Advisory Boards are not getting the information to the EPA. So there must be a cost associated with just this one portion. So in that regard, Mr. Chairman, I'm speaking in support of Ms. Edwards' amendment, and I yield back. Thank you.
Mr. Chairman, this amendment is really the sibling to my last amendment, although I hope this one will have a bit more support from the majority. As we discussed before, the underlying bill we're marking up today adds many new costly requirements, unknown costly requirements, to the EPA's existing Science Advisory Board process. However, nowhere in the bill does Congress provide any additional resources to the EPA to carry out these new requirements. My last amendment was an attempt to rectify this by providing authorization to EPA for these additional resources. And if you didn't like that amendment, you should really be fine with this one, as it adds no additional money. The amendment simply says that Congress isn't going to pass an unfunded mandate on to the EPA. If the Congress doesn't provide the EPA with the funds necessary to carry out the newly created and costly requirements in the bill, then the administrator doesn't have to implement those requirements. I think it's a pretty reasonable approach. And you know, we hear a lot of demagoguery about the Federal workforce. Well, a lot of these people are my constituents. They're hardworking public servants who in many cases are making a lot less money than their private sector counterparts for work that's vital to our country. I think it's incumbent on us as legislators to provide them with the conditions they need to succeed. And if we tell the Federal workforce to do something, we should provide them with the resources to do it. Otherwise, we just set them up for failure. And that's a real disservice not just to the hardworking public servants of the country, but also to the public. And since the majority has apparently decided not to provide the resources necessary to implement the Act, then we should adopt this amendment and not set the EPA up for failure by imposing upon them an unfunded mandate.
This amendment really addresses one of my deepest concerns about this bill. I'm very disappointed that the majority has not provided the means to pay for the new requirements it created for the Science Advisory Board in this bill. And since the majority does not support providing the EPA with the authorization, just to make sure that we at least understand that we're adding additional chores and responsibilities, we should at least authorize, not appropriate, but authorize for the work. At the very least, support the simple and common sense amendment. This amendment only seeks to ensure good government by allowing EPA to avoid carrying out these new regulatory burdens unless the Congress provides the monies to fund them. We find this to be becoming rather common, that we overload our agencies with lots of responsibility, but we do not supply them with the adequate resources to do it. There is a simple principle at work here. You should pay for what you buy. In this case, the majority has sought to buy additional governmental services without paying for the services. As every child is taught, it is wrong to take without paying. This amendment seeks to right that unfairness by assuring that the EPA doesn't have to provide these additional services unless the Congress is willing to pay for them. On a simple principle of fairness, I fully support this amendment and urge my colleagues to adopt it. I yield back.
Mr. Chairman, there is a uniform law called the Federal Advisory Committee Act that applies to this board and literally over 1,000 other boards throughout the Federal Government. The purpose of this amendment is to ensure that we don't balkanize the law that applies to such bodies. I say this recognizing that this could provoke a lengthy conversation between myself and Congressman Rohrabacher about the Balkans. This is the last amendment before us today. My staff has prepared an amazing and scintillating justification for this amendment, and I yield the remainder.
The gentleman.